I did a consult today for a client with 9 children and 19 grandchildren, and I want to say 8 great-grandchildren. The client, the prospective client, it's an actual client now, is not an elderly person. It's an older person, but so many children and grandchildren and great-grandchildren. The question came up. One of this person's children had predeceased this person, right? So a child of the will maker. I'm going to use this as a will client. It could have been a will. It could have been a trust. Might be both. Let's use will. What's a will? A will says, hey, upon my death, if I have this item, this thing, this property, this account, this money, anything that I own, right? The stuff from my life. If I own that at the time of my passing, this house, I want it to go in a certain way. That's what a will basically says, right? This person, one of this person's children, predeceased. How do you handle that? What do you do in terms of, do you keep the percentage that child would be entitled to? Do you keep that percentage and give it to the children of your deceased child, or do you not? So 8 children, 1 passed away. What should this parent do? And I'm only framing it like that as a point of conversation. There is no should about it. The person makes their own decision, and it could be divide everything in 7 ways for the 7 surviving children, or it could be let's divide everything in 8 ways. 7 for the children that are alive, and a 1/7 share to the children of that deceased person. In effect, the grandparent is giving to the grandchildren, but only in the percentage that the parent would have gotten. So fairness is in the eye of the beholder. There's no hard and fast rule. Right? You can disinherit children. So this person doesn't have to leave to any of the surviving children. All of the assets of this person can go to a charity, can go to a hospital, go to a friend. It's up to the individual person. That's the estate plan for this person. It could be all, some, none, or any other percentage. It doesn't even have to be an even percentage. By way of conversation, I'm using for 8 children, 1/8, or 7 surviving children, 1/7. Doesn't have to go that way. The favorite child could get 50%, and all the rest could share 50%. The several children that were supportive of the parent, say 4 children really helped out this parent, maybe they receive all of the benefits of the person's assets. And the ones that haven't been around, haven't helped, haven't been in the life of the parent, they could go hop. 4 ways that I can help you and your family. 1, get an estate plan, a trust or a will, or at least information leading to you using beneficiary designations, perhaps even a deed transfer on death. Just went into effect. Well, it's not in effect. The law was just signed. That might be an option for you. Beneficiary designations, joint accounts, wills, or trusts. That's number 1. 2, watch my videos. You can learn so much from me teaching you by video. 3, avoid nursing home poverty. Plan in advance with an irrevocable trust. And 4, what's 4? Did I write down 4? Yes, come to a workshop. Come to an estate planning or guardianship workshop. I do 2 a month. I discuss for guardianship, incapacity planning. No, that's in the trust. That's in the estate plan. For the guardianship, from the filing of a petition, the alleged incapacitated person, all the way through judgment. I discussed that in a webinar. And for estate planning, I go over advanced directives, healthcare proxy, living will, power of attorney, HIPAA, and I discuss probate, a probate avoidance trust, and a Medicaid asset protection trust. All of that and more. Please join. Take a look. FrankBrunoLaw.com. Thank you.